This is an excerption from Library of Congress. A link under the title Magna Carta, Muse and Mentor, Due Process of Law. Due process of law is a constitutional guarantee that prevents governments from impacting citizens in an abusive way. In the modern form, due process includes both procedural standards that the courts must uphold in order to protect people's personal liberty and the range of liberty interests that the statutes and regulation must not infringe. It traces origins to Chapter 39 of King John's Magna Carta, which provides that no free man will be seized, dispossessed of his property, or harmed except by the law of the land, expression that it referred to customary practices of the court. The phrase due process for law first appeared as a substitute for Magna Carta's the law of the land in the 1354 statute of King Edward III that it restated Magna Carta's guarantee the liberty of the subject. The 5th and 14th Amendments to the Constitution, which guarantee that no person shall be deprived of life, liberty, or property without due process of law, incorporate the model of the rule of law. The English and American lawyers associated most closely with the Magna Carta for centuries. Under this model, strict adherence to regular procedure was the most important safeguard against tyranny. Over time, courts in the United States have ruled that the due process also limits legislation and protects certain areas of individual liberty from regulation. Due process of law, next section. This comes with a picture called Due Process, the statute in Statute Nova, first Edward III to 20 Richard II, that is 1354. The picture for bound manuscript on volume 15th century. Again, it's a law library, the Library of Congress. The notes to or comment to this picture is due process law during the rule of Edward III that reigned from 1327 to 1357. Parliament enacted 6 statutes to clarify the meaning and the scope of the liberties that Magna Carta guarantees. The statutes interpreted the expression the law of the land, which appeared in Chapter 29, as the judicial procedures that protect the subjects' liberties. One of the laws enacted in 1354 introduced the term due process for law, the first appearance of that phrase in Anglo-American law to describe Magna Carta's procedural guarantees. The 5th Amendment to the United States Constitution evokes this language in its due process clause. A second section is Dr. Boham's case. Again, it's come with a picture. The caption to that picture is Edward Cook, 1554 to 1634, Dr. Boham's case in Cook's Reports, Part 8, London Society for Stationaries, 1611. Dr. Thomas Boham's case came from Chief Justice Edward Cook of the British Court of a Common Pleas in 1610. At issue was a law that gave the London College of Physicians the power to imprison anyone practicing medicine without a license. Cook argued in his decision that the law was void for being against common right and reason. American jurists in the colonial era cited this case in support of the principles and statutes that conflict with the fundamental law that a void is often held to be the antecedent of both the doctrine of substantial due process and judicial review. The next section is John Armour Bingham, with a picture that is a portrait of John Armour Bingham, 1815 to 1900. Okay. The text to it is the 14th Amendment to the Constitution was ratified on July 9th, 1868, and granted citizenship to all persons born or naturalized in the United States, which included former slaves recently freed. In addition, it prohibited states from denying any person life, liberty, or property without due process of law, or denying any person within its jurisdiction the equal protection of the laws. Serving on the Joint Committee on Reconstruction, Ohio Representative John Armour Bingham was a sponsor and principal framer of the 14th Amendment. Next section, one country, one constitution, and one people. John Armour Bingham was a copy or a photo of his article or publication under the title One Country, One Constitution, and One People, speech, by Honored John A. Bingham of Ohio in the House of Representatives, Washington, D.C., Congressional Global Office. Okay. Let's see. Congressional opponents to the 14th Amendment argued that the amendment would undermine the legislative powers of states. John Armour Bingham believed that the proper interpretation of the amendment's privileges and immunities clause included most of the rights enumerated in the first 8 amendments of the Bill of Rights. The amendment would therefore require state governments to adhere to the same standards as the federal government in protecting the rights of their citizens. In his defense of the amendment before Congress, Bingham argued that it was a fulfillment of the Constitution's promised enjoyment of life, liberty, and property. The next section is the Slander Horse case, which is a famous case. Okay, Stephen G. Field, exactly, that's Chief Justice Field's his time. The 14th Amendment on the Constitution considers the right to pursue any lawful trade or avocation without the restraint, dissenting opinions of U.S. Supreme Court in the New Orleans Slander Horse case. That is in 1873. I actually just read that in the history on the Supreme Court by Justice Linquid. So anyway, let's see the Slander Horse cases. Slander Horse cases were the series of cases before the U.S. Supreme Court that considers the extent to which the 14th Amendment placed limits on the state's legislative powers. While the majority of the court interpreted the amendment narrowly, Justice Stephen G. Field's dissenting opinion argued that I think he's sitting justice. I forgot. So I think he's the Chief Justice. No, Chief Justice was still Chase. Yeah, so anyway, the sitting justice. I'm not so sure now. So Justice Stephen G. Field dissenting opinion argued that the amendment to protect individuals from state legislation infringe upon their privilege and immunities under the federal Constitution. Field's dissenting opinion is often seen as an important step towards a modern doctrine of substantial due process, a theory that the court has developed to defend rights that are not mentioned in the Constitution. Okay, the Miranda decision on the next section. That is Warren notes concerning Miranda versus Arizona, 1966. That is a snapshot of that. Chief Justice Warren's early draft opinion in Miranda versus Arizona shows his thought process regarding the decision that required police to warn arrested suspect that the government could use any information provided as evidence and to advise the suspect the right to remain silent and the right to counsel. Warren argued such a warning was required by the Fifth Amendment's right against self-incrimination. Tracing the history of the right against self-incrimination, Warren recalled the trial of John Leybourne, a 17th century radical politician who contended that freedom from compulsory self-incrimination was one of the fundamental rights of an English subject. In that section, the right to remain silent. Herbert Bloch, 1909 to 2001. You may or may not have the right to remain silent, depending on whether the Supreme Court decides that nothing it has already said may be held against it, published in the Washington Post, December the 8th, 1999. That is a cartoon picture, basically. Okay. A political cartoon by Herb Bloch lampoons the Supreme Court decision to hear the case of United States versus Dickerson, which challenged the constitutional requirement to recite Miranda rights to an arrested suspect. The case concerned a federal law that Congress passed in 1968, designed to bypass the Supreme Court 1966 decision. In Miranda versus Arizona, the court decided that because Miranda was a constitutional decision of the United States Supreme Court, Congress exceeded its authority in passing the law. The next section, the struggle to perfect the Constitution. Thurgood Marshall, 1909 to 1993, speech concerning the bicentennial of the United States Constitution, April the 2nd, 1987. This is the draft typescript. Okay. In address on the occasion of the bicentennial of the American Constitution, Thurgood Marshall, the first African-American Justice of the United States Supreme Court, argued that the U.S. Constitution was deeply flawed in its creation and has required substantial change to bring it to its present state. He said, while the Union survived the Civil War, the Constitution did not. The Civil War and the 14th Amendment provided a new basis for justice and equality, ensuring protection of life, liberty, and property for all persons against deprivations without due process. That's end of this. Yeah, this is the end of this article. Okay, I wish I could read that. Unfortunately, can't. Don't really have that article in links. Anyway, I'm gonna stop here.